Sir, I need to see some ID. Right now. May I ask what I've done that requires identification? You've been sitting here for 2 hours and people are uncomfortable.
Reading in a public library makes people uncomfortable?
Don't get smart. ID, now.
I don't have to produce identification for sitting in a public space. You know that.
Officer Dale Cowan, badge number 471, had been with the Mecklenburg County Library Security Division in Charlotte, North Carolina, for 8 years under a contracted law enforcement partnership between the county library system and the Charlotte-Mecklenburg Police Department. In those 8 years, he had accumulated 15 formal complaints, 10 filed by Black library patrons, all describing the same documented pattern: demands for identification from individuals engaged in lawful library activities, selective enforcement of occupancy behavior policies against Black patrons, while identical behavior by white patrons went unchallenged, and a specific pattern of escalating encounters when individuals asserted their legal right to remain in the building. Every complaint had been submitted to the library system's Patron Services Office. Every complaint had been reviewed. Every complaint had been closed with a notation that the officer had exercised appropriate discretion. Not once in 8 years had the library system's security contractor been asked to explain why 92% of Cowan's documented enforcement actions involved Black patrons in a library system where Black residents represented 41% of registered cardholders. On the afternoon of March 9th, at 2:17 p.m., Cowan was completing his third circuit of the main branch's second-floor reading room when he observed a Black man in his late 40s seated at a window table in the periodicals section, with a leather briefcase on the table beside him, reading from a legal brief. The man had been at the table for 2 hours. He had not disturbed anyone. He had not raised his voice. He had not used his phone. He had not eaten or drunk anything. He had been reading, with the focused stillness of someone doing professional work, and the only complaint Cowan had received, logged at 2:09 p.m. in a note from a library volunteer named Susan Parks, described a patron who seemed out of place without specifying any policy violation. Cowan had read that note and decided it was enough. What Dale Cowan did not know was that the man reading the brief was Nathaniel Ellison Cross, civil rights attorney, partner at Cross, Washington and Aldridge, LLP, recipient of the American Bar Association's Thurgood Marshall Award for Civil Rights Litigation, who had argued successfully before the Fourth Circuit Court of Appeals 11 times, and who had, in 31 years of practice, filed and won civil rights lawsuits in 14 states, and that the brief he was reading was a Fourth Amendment case scheduled for oral argument in 6 weeks, and that the briefcase beside him contained, among other things, a digital recorder he used for professional dictation that had been running since he sat down, and that the encounter Cowan was about to initiate would be the most precisely documented civil rights violation of his career, recorded, time-stamped, and ready for filing before the week was out. Before we go any further, drop where you're watching from in the comments. And if you believe a civil rights attorney should be able to sit in a public library and read a brief without being told to produce identification for making someone uncomfortable, hit that like button and subscribe. Because what Dale Cowan did on the second floor of the Mecklenburg County Main Library on March 9th was not a security decision. It was 15 complaints walking up to the one table in the building that was the worst possible place to stop. Nathaniel Cross had been coming to the Mecklenburg County Main Library since he was 9 years old. His mother had brought him on Saturday mornings, when the family's apartment on Beatty's Ford Road didn't have the quiet he needed to read. She had taken the 29 bus with him, paid his library card fee, and told him that everything worth knowing was in this building, and that he had as much right to be in it as anyone alive. He had believed her then. He believed her now, at 51, sitting at the same window table on the second floor that he had used as a boy, because the table had the right light and the right angle on the street below, and because some habits were worth keeping. He was a civil rights attorney. He had been one for 31 years. He had graduated from North Carolina Central University School of Law in 1994, joined a small civil rights firm in Durham at 25, made partner at 33, and established his own firm, Cross, Washington, and Aldridge, at 39. The firm had 14 attorneys and a practice that was 80% civil rights litigation and 20% civil appeals. He had won cases involving police misconduct, employment discrimination, voting rights, and housing discrimination in federal and state courts across 14 states. He had argued before the Fourth Circuit 11 times and had won 10 of those arguments. He had argued before the Supreme Court once, in a Fourth Amendment case involving pretextual stops, and had received the ABA's Thurgood Marshall Award 3 years later at a ceremony in Chicago, where he had spoken for 12 minutes about his mother and the 29 bus and the library on West Trade Street. He was at the library on March 9th because his office was being renovated. A water pipe had failed over the weekend, and because his most reliable alternative working environment when the office was unavailable was the second floor of the main branch, where the light was good and the ambient noise was low enough for the kind of concentrated reading that a appellate briefing required. He had arrived at 12:14 p.m. He had signed in at the reference desk, his name in the visitor log, time-stamped, visible, and had gone to his table. He had been reading for 2 hours and 3 minutes when Cowan appeared. He heard the footsteps before he saw the officer. He recognized the cadence, the particular walk of someone on patrol who has identified a destination. He kept his eyes on the brief he was reading. He finished the paragraph he was in. He set the brief down with the precision of someone who intended to return to it shortly. He looked up. Cowan was 39 years old, broad through the chest, with the specific expression of someone who had decided what the situation was before arriving at it. He stopped 2 feet from the table. He looked at Nathaniel. He looked at the briefcase. He looked at the brief. "Sir, I need to see some ID right now." Nathaniel looked at him. He looked at badge 4471. He noted the absence of a library-issued contractor credential. Cowan was in uniform, but his contractor lanyard was tucked into his shirt pocket rather than displayed. He looked at the small digital recorder on the table beside his briefcase, which had been running for 2 hours and 3 minutes, and which was now running for a different reason than professional dictation. "May I ask what I've done that requires identification?" he said. "You've been sitting here for 2 hours and people are uncomfortable." Nathaniel looked at the table to his left, a white woman in her 30s reading a novel, who had been there for approximately 40 minutes by his count and had not looked up. He looked at the table to his right, empty. He looked at the periodicals area behind Cowan, where 3 other patrons, all white, were seated with no officer present. He looked back at Cowan. "Reading in a public library makes people uncomfortable," he said. "Don't get smart, ID. Now, I don't have to produce identification for sitting in a public space. You know that." Cowan stepped closer. The specific proximity of someone who had learned that physical presence communicated authority more efficiently than legal argument. "You're going to produce it or you're going to leave." "I'm going to do neither," Nathaniel said. His voice held the complete evenness of someone who had made this argument in courtrooms and depositions and congressional testimony for 31 years, and who understood that the quality of his composure was itself evidence. "I'm going to sit here and finish this brief. And when I'm done, I'm going to write down your badge number, your name, and everything you've said for the past 4 minutes. Because where I come from, this exact situation has a legal name. It's called pretextual harassment. And where I come from is a courtroom. I've been in 314 times, and I've never lost a civil rights case." Cowan's expression shifted. Not with recognition, with the specific irritation of someone whose authority had been challenged with precision rather than emotion, which was harder to dismiss. "I don't care what kind of cases you've been in. You're going to show me ID or I'm going to escort you out." "On what policy basis?" Nathaniel said. "Cite the specific library policy that requires identification from a patron seated in the public reading room." Cowan could not cite it, not because it didn't exist, but because the policy that existed, a zero-tolerance policy for disruptive behavior, did not describe anything Nathaniel had done, and Cowan had not framed his approach around any policy because he had not begun with policy. He had begun with the note from Susan Parks and with the judgment he had made in 15 documented cases before, that a black man in a space required his attention more than the same activity by a white patron required anything, he said. "You're creating a disturbance," I am reading Nathaniel, "in a library, in silence, with both hands visible on the table. I have disturbed no one. He looked at the woman at the next table. Have I disturbed you? The woman, whose name was Layla Osi and who had a master's degree in library science, and who was in the reading room doing research for a graduate seminar, looked at Cowan and said, "No, he's been completely quiet since I sat down." Cowan looked at Layla. He looked at Nathaniel. He said, "Mom, this doesn't concern you." "She was speaking to me," Nathaniel said, "and her answer is on the record." He looked at the digital recorder. That recorder has been running since 12:14 p.m. It has captured this entire conversation with timestamp accuracy. I want you to think very carefully about what you say next. "You need to come with me," Cowan said. He reached for Nathaniel's arm. Nathaniel did not move away. He said, clearly for the recorder, "Officer Dale Cowan, badge 4471, is attempting to physically remove me from a public library reading room after failing to cite any specific policy I have violated, after being unable to articulate the specific behavior that constitutes a disturbance, and after I have informed him that this conversation is being recorded." He paused. "I want the library director here. I want a CMPD supervisor here. And I want both of them here before you touch me again." Cowan's hand, which had been on Nathaniel's arm, came away. The reading room had gone very quiet. Layla Osi had her phone in her hand. A librarian named Marcus Webb, who had been at the reference desk at the end of the reading room and had heard the exchange, had walked to the periodicals section and was standing 12 feet away, watching. A graduate student at the corner table had his head up and his phone down and visible on the table, with its recording light active. Cowan looked at the recorder. He looked at Layla's phone. He looked at Marcus Webb. He looked at the graduate student's phone. He looked at the brief on the table, the Fourth Amendment brief, and for the first time he registered what he was looking at. A professionally prepared legal document, dense with citations, with a case name printed at the top and a firm name below it. Cross, Washington and Aldridge, LLP. He looked at the briefcase. He looked at the ABA membership card visible in the outer pocket of the briefcase, the gold seal of the American Bar Association, and below it a name he had not read until now. He read the name. He looked at the recorder. He looked at Nathaniel. Nathaniel said, "My name is Nathaniel Ellison Cross. I am a civil rights attorney. I am the founding partner of Cross, Washington, and Aldridge. I have spent 31 years litigating cases that look exactly like this one. And I am telling you, clearly, with everything recording, that what you have just done in this reading room is the most well-documented act of pretextual racial harassment I have personally witnessed in 3 decades of practice, because I was sitting at this table when you did it." The specific quality of what happened to Cowan's posture in the subsequent 5 seconds was captured on Layla Osi's phone, on the graduate student's phone, on the library's overhead camera, and on Nathaniel's digital recorder in full audio. It was the posture of a person realizing, sequentially, the full weight of what they had done. The recorder that had been running for 2 hours, the name on the brief, the ABA card, the phones recording from 3 angles, and the 31 years of civil rights cases waiting on the other side of the table. He said nothing for 4 seconds. Then he said, "I was responding to a complaint." "From whom?" Nathaniel said. Cowan could not answer. Because Susan Parks was a library volunteer, and her note had described a patron who seemed out of place, which was not a complaint in any documented policy sense, and which would not survive 30 seconds of cross-examination from the man sitting in front of him. "I'd like the library director now," Nathaniel said. "Please." Library Director Constance Ibarra arrived at the second-floor reading room at 2:39 p.m., summoned by Marcus Webb, who had called her office directly rather than routing through the security contractor's chain of command, because Webb had 22 years in public libraries and understood what he had just watched. She walked into the reading room, identified the situation from 6 feet away, and said, "Mr. Cross." She knew him, not personally, but professionally. His firm had been involved in a pro bono case that the library system's legal department had cited in a policy brief 2 years earlier. She had seen his name in documents. She was now seeing it on the ABA card in the briefcase pocket at the table where one of her contracted security officers was standing with the specific posture of someone who understood that they had made an error they could not scale. She looked at Cowan. She said, "Wait by the reference desk." Cowan walked to the reference desk. He did not look at Nathaniel as he left. Ibarra turned to Nathaniel. "Mr. Cross, I apologize. What do you need from me?" I need the contractor's incident report for this interaction preserved before it can be amended. I need the library's overhead camera footage from the past 30 minutes preserved as evidence. I need the name of the patron who filed the complaint that initiated this contact. And I need this officer's assignment history at this branch, including any prior complaints filed by black patrons. He paused. You can tell him he can go. Ibarra radioed Cowan's supervisor at the security contractor's district office. The message was brief. Cowan was relieved of his library assignment pending review. He was told to go to the contractor's district office and wait. He walked through the library's main floor, past the circulation desk, past the children's section where a story time group was gathered, past the entrance hall where the original founding plaque listed the library's charter. Free and equal access to knowledge for every resident of Mecklenburg County. He walked through the doors and did not return to the building in any professional capacity. The contractor's internal review opened the following day and was completed in 16 days. The evidence was unambiguous across 4 sources: the library's overhead camera, Layla Osie's phone recording, the graduate student's phone recording, and Nathaniel Cross's digital recorder. 2 hours and 27 minutes of continuous audio that included the ambient quiet of the reading room before Cowan's arrival, the complete exchange in full, Leif's response, the 4 seconds of silence after the ABA card was read. Cowan's complaint history was produced in full. 15 complaints, 10 from black patrons, all closed. The library system's legal team reviewed them alongside the March 9th recordings and produced a finding that the contractor's attorneys received on a Thursday and did not dispute. Cowan had applied an occupancy and comfort standard to black patrons that he had not applied to white patrons in documented observation logs, and the pattern had been documented, reviewed, and repeatedly classified as appropriate discretion by a system that had confused compliance closure with accountability. Cowan was terminated from the library security contract 33 days after the incident. His CMPD liaison credential was reviewed and revoked. His North Carolina law enforcement certification was referred to the NC Criminal Justice Education and Training Standards Commission. The commission reviewed the camera footage, the complaint history, and the contractor's finding. Permanent decertification was recommended and adopted. His pension contributions from 8 years of service were reviewed under the contractor's misconduct clause and forfeited in full. He applied to 2 other security contracts in the Charlotte area. Both background checks returned the decertification and the contractor's termination for cause. Neither application moved forward. He found work in a retail stocking position in a big box store in Cabarrus County, 3rd shift, no public interaction required. His name returns 230,000 search results. The civil lawsuit was filed by Nathaniel Cross through his own firm, Cross, Washington, and Aldridge, because 31 years of civil rights practice had prepared him for exactly this filing, and because he had decided on the drive home from the library that the case was too well documented to leave to someone who cared less about the precision of the complaint. The lawsuit named Cowan personally, the security contractor institutionally, and Mecklenburg County as the entity responsible for the contractor relationship and the complaint review system that had closed 15 complaints without corrective action. The complaint alleged racial discrimination in the provision of public library access, violation of First and Fourth Amendment rights under color of law, and institutional negligence. 15 complaints over 8 years, all closed, enabling the pattern that produced a pretextual harassment of a civil rights attorney at a public reading table. The county's legal team reviewed the complaint. They reviewed the 4 recordings. They reviewed the 15 closed complaints. They reviewed the graduate student's phone footage, which showed 3 white patrons in the same reading room, doing the same activity as Nathaniel Cross, without any officer contact during the entire 22 minutes of footage before and after the encounter. They opened settlement discussions in the 2nd week after being served. The settlement was finalized 3 months later, $1.6 million. The county's liability carrier contributed $900,000. The contractor contributed $500,000, reflecting the institutional failure to address 15 complaints over 8 years. Cowan's personal liability was $200,000 attached to his assets. His wife filed for separation the month the settlement was announced. Nathaniel Cross directed the settlement proceeds with the same precision he had applied to every financial decision of his professional life. $700,000 established the Cross Public Space Access Fund, administered through the North Carolina Justice Center, providing legal support to North Carolina residents who had experienced racially discriminatory removal or harassment in public facilities, libraries, parks, transit stations, government buildings, and who lacked the resources to pursue civil remedies. The fund accepted its first intake inquiries the week it launched and received 190 in the first 30 days. $500,000 went to the North Carolina Central University School of Law, his alma mater, to endow the Pretextual Enforcement's Litigation Clinic, a supervised clinical program training law students to identify, document, and litigate pretextual enforcement cases under the 4th and 14th Amendments. The clinic's first cohort enrolled 6 months after the endowment was finalized. $400,000 established the Mecklenburg County Library Access Initiative, a partnership between the library system and 3 community organizations providing digital literacy support, library card enrollment assistance, and legal consultation to residents who had experienced library access issues. The initiative was housed in the main branch, on the 2nd floor, in a meeting room 40 feet from the window table, in the periodicals section. The North Carolina Public Facility Equal Access Act, introduced in the state legislature 9 months after the settlement by a bipartisan group of legislators who had been following the case, required all county and municipal public facilities using contracted security personnel to implement mandatory complaint tracking visible to facility directors, annual reporting of enforcement action demographics disaggregated by patron race, and automatic external review of any security officer whose enforcement actions showed a statistically significant racial disparity over any 12-month period. The act further prohibited the closure of any patron complaint against a contracted security officer without documented disposition, eliminating the appropriate discretion classification that had been used to close 15 complaints over 8 years without requiring any accountability. The act passed both chambers of the North Carolina General Assembly and was signed into law. Nathaniel Cross was present at the signing. He stood in the back of the room, as he always did at ceremonies. He watched the governor's pen touch the paper. He thought about his mother and the 29 bus. He thought about the note on the table he'd written when he was 9, in the careful printing of a child who was learning to believe that what he wrote mattered. N. Cross, table 4 window, reserved. Nobody had ever told him he could do that. He had done it anyway. He had been doing it ever since. Dale Cowan worked the 3rd shift at a big box store in Cabarrus County. He stocked shelves from 10 p.m. to 6 a.m. and drove home in the early morning light. His certification was permanently revoked. His name appeared in the North Carolina Public Facility Equal Access Act's legislative record as the precipitating case. It appeared in every library security contractor's training curriculum developed under the Act's new requirements. It appeared in a University of North Carolina Law Review article titled Cowan and the Comfort Complaint: Pretextual Enforcement in Public Spaces and the Evidentiary Value of Ambient Recording. His appeals for pension reconsideration were denied twice. The 3rd appeal was filed by a new attorney and was still pending. The library's 2nd floor reading room was the same room it had always been. The same light through the same windows, the same tables, the same chairs. The overhead camera, upgraded as part of the settlement's facility improvement provisions, now covered every table in the room without blind spots. Table 4, by the window in the periodicals section, was usually occupied in the afternoons. The person who sat there most often came in around noon, signed the visitor log at the reference desk, went upstairs, opened a briefcase, and read for hours without disturbing anyone. He had been doing it since he was 9 years old. Nobody had ever given him permission. Nobody had ever needed to. If you believe a civil rights attorney should be able to read a brief in a public library without being told to produce identification for making someone uncomfortable, share this story with someone who still thinks the word uncomfortable is a sufficient basis for involving law enforcement. What specific accountability mechanisms should every public facility implement before renewing any security contractor's agreement? Drop your answer in the comments. And if you believe 15 complaints over 8 years that were all closed as appropriate discretion is the definition of a system that was never designed to produce accountability, subscribe. We are not stopping until appropriate discretion stops being the phrase that makes complaints disappear before anyone has to answer for what they describe.